Welcome to Promote, Profit, Publish. I'm so excited to have a really cool guest today. But before we get into that, I want to invite you guys over to take the Promote, Profit, Publish quiz at www.promoteprofitpublishquiz.com. Find out how your entrepreneurial marketing skills line up to where you should be and what you need to know to really do this effectively. So, my guest today is Jason Webb. And I've known Jason for a while now. He's a pretty cool guy. I actually saw him eat the feet of children playing in the pool. No, he didn't really eat them, but he told them he ate them. It was kind of like that nose thing you do when you're a kid, and only you knew they still had their feet. So, Jason, I hope you get business after that, Jason. I probably just
Right.
you ever getting business again.
What kind of business I get may be different, but it's okay.
Yeah. So Jason is an intellectual property attorney and a partner at Pearson Butler in Utah. He has a bachelor's degree in applied physics and computational modeling from BYU, which means he's a super smart guy, and we probably won't understand a word he says because who knows anything about applied physics. He also assisted in experimental laser physics and cancer research. He has a law degree, obviously, and specializes in deep experiences with patent, trademark, and copyright law. And that's actually what we have him on today. He's successfully negotiated licensing agreements and settlement agreements for his clients with Fortune 500 companies. And I'm having him on today. Welcome, Jason.
Awesome. Excited to be here.
Good. Don't need any feet while we're on the air.
Okay.
The reason I wanted him to come in today is I just saw him at Magnify Your Wealth in San Diego, which it's kind of funny because Jason lives very close to me in Utah, and we never see each other except at events in other states.
Yeah.
But we had a conversation about trademarks and coaches with programs and copyrights and all that kind of things. And I thought that it'd be really great to share some of his expertise today. So share away. No. So how if you have books, products, and services,
Mhm.
how do you know what to protect?
Yeah, so that's a great question. So there are a lot of things that you could protect, and you want to be able to prioritize. Well, first you want to identify what's even possible to protect. And so the things that you can protect are things that you've created, that are creative, that they're new, that they're different, that they're distinctive, there's something special about them, right? And so you could just do that. You could just go through a list of everything about your business and everything about what you plan for the future for your business and write down all the things that sort of meet those criteria, because those are the things that tends to be protectable. And then what you want to do is you want to prioritize those and maybe look at which are the ones that are most important to the revenue streams, right? Because that's the lifeblood of your company. Um, and that'll help you filter things to the top of the list that are maybe more important than some of the other things that maybe you love a lot, that maybe are really valuable to you, personally, but maybe they're not quite as valuable to the company financially. You could spend a whole lot of money on protecting intellectual property, but you want to think of it as an investment. You're investing in your business, you're investing in helping your business to grow and to thrive and succeed. And so those things that are closest to those revenue streams, they're the things that make the most difference.
So one of the conversations you and I had was about the book world.
Mhm.
And I think this happens a lot in the music world as well, that people are under the impression that if they mail their material to them, it is now copywritten. And so, and you and I had the conversation about that might be all fine and well, but it's not enforceable.
Yeah, and I don't know how that myth persists, but it just does. It's just one of those things that I just, I never stop hearing about. It doesn't help at all to do that. It's no help. One, it doesn't give you any copyright rights or give you any trademark rights or allow you to license anything. It doesn't. So it doesn't do anything. The only thing that you could use it for would be to try to prove a date that you had thought of something or come up with an idea or created something. Um, the problem is that if you're relying on that, you take that into court. You open it in front of the judge, and voila, here's the thing, and it has the date stamp on the envelope. The next day, through lots of different techniques that are really easy to do, that you could look online and learn how to do it, they could come in with another envelope that's dated around as old as yours is, and open it up and have today's newspaper. And so then you look like you're a liar, you look like a charlatan, like you're trying to, trick everybody. If you're really trying to prove that something happened on a certain date, then it's way better to have witnesses sign that thing. So you'd take that same document and you'd have some people who are trustworthy, who have, good backgrounds, would be good witnesses in court. You have them sign and date the bottom and have them state something like, seen and understood by, and then they sign their name and then they date it, right? And that's far more persuasive in court. The thing is that proving that something happened on a certain date doesn't come up very often. So,
Um, but there's a better way. I mean, you can actually copyright it, right? Like
yeah,
formally, which you have a certificate, you have something issued by the government that proves it.
yeah, and the government has something on record, and the government has, stamped it with a particular date, right? And that's not a date that anybody can really contest. That that date shows up in court. There's nothing they can do about it to make that date go away. The government said that it happened. So,
Mhm.
so a copyright registration, a trademark application, those both get date stamped as soon as we file it. And not only does that date matter to prove, hey, I had this idea or I came up with this by this, at least by this date, the date matters for actually giving you enforceable rights. So filing copyright registrations, filing trademark registrations, that makes a big difference in the rights that you have, and the damages that people can be subject to for copying your things that are protected. They can be huge damages. I've seen companies completely fold because they got copied. Both. I've seen companies completely fold because they got copied and they couldn't do anything about it because they didn't do the right stuff in the beginning. I've also seen companies fold because they copied somebody else's stuff, got caught, and that company had done what needed to be done to be able to put leverage against them. So this is and it makes sense because typically about 60 to 80% of the value of most companies in America today is in their intellectual property. And so if you have a hold on that asset, right, that amount of value, that's enough to swing a company to either make it or not.
So let's say that I did everything I was supposed to do,
Mhm.
but then I can't afford to enforce my rights. What happens then? What if I just can't take
Mhm.
somebody to court? I don't have the money. Attorneys like you are really expensive.
Right, we are. It's crazy. Um, I'm part of the American Intellectual Property Law Association, and we take stats all the time. Every 2 years, we do this big, huge questionnaire, and then we get a book that tells us what everybody else has been saying about those questions. Right. One of the things that you see is that it's hundreds of thousands of dollars to do a lawsuit, start to finish, to enforce your intellectual property rights, and I don't know anybody that has $400,000 sitting around doing nothing, waiting, to sue somebody. But it doesn't come down to that. Less than 5% of disputes ever make it to a complaint. Most of the disputes are resolved and dealt with a cease and desist letter and maybe a little bit of negotiation. And even small businesses can handle that cost, right? You're looking at hundreds of dollars, maybe a few $1,000s, and then you're done and the problem's solved. Of those less than 5% that go to a lawsuit, less than 5% of those make it all the way through the lawsuit. So that 200 grand or 400 grand or $500,000, almost nobody's spending that. That's just that's more big Fortune Fortune 500 companies that are, running into things like that. Everybody else is resolving their disputes early and getting some good justice without having to spend tons of money.
Good. Okay. So, I think one thing that we get mixed up on a lot as entrepreneurs is what's the difference between a copyright and a trademark? Like, are they
Yeah, great.
separate things?
Yeah. So for one, if you feel like you've got something to protect, whether you go to an attorney and say, I want a trademark, or you go and say, I want a copyright, if you're wrong about what you're saying, the attorney will figure that out pretty soon. And so I wouldn't stress too much about having to know the answer to that question. That said, it is nice to know. So a copyright is about protecting content. So that's where we're protecting books, videos, sculptures, paintings, photographs, illustrations, website development, computer code. Those are all things that are protectable by copyright. It's your content, right? And it needs to be something that you've created. So the author is the one that owns the rights to that, unless they sign the rights away. But whoever it is that created it, they've created something, and that something is protectable. Now it's automatically protectable under common law copyright, but that protection is very, very weak, and it doesn't give you hardly any leverage to do anything more than just ask someone to stop, right? Which is not very much leverage. Trademark, on the other hand, is for protecting elements of your branding, and your branding is how people find you. So that's your company name, those are your product names, those are taglines that you use. It could be trade dress, right? So like, bottle designs for liquor companies. The Apple Store has a trademark registration on the way the Apple Store looks, just the way everything's all lined up and open and in that particular array with the tables. So anything that when people see it, they're like, oh, I know which company this is involved with, right? The brown trucks, you can see a big, huge brown boxy truck on the road, not see any lettering on it, and you'll just assume it's UPS, right? All those things are things that are protectable by trademark. And so you can kind of think of it, if you're in the business of teaching or coaching or writing books, or you're an expert, those sorts of things, a lot of times your copyright protects what you're selling, and your trademark protects how they find you to buy what you sell, right? And so you don't want somebody else using the way that people find you to find them too, because then some of your customers will siphon off to someone else, and that's not fair, right? You also don't want someone else to be selling what you sell, right? You want to be the only place where they can get this particular piece that you're selling, right? So by having a monopoly on how to find you and a monopoly on what you sell, you're able to have good pricing for yourself. You're able to manage and control the interaction with your customers, right? I mean, can you imagine if someone bought something from someone else, thought they bought it from you, it turned out it sucked, and then they're posting reviews online about you, about how your stuff sucks, right? And it doesn't make any sense from what they say about it, because yours doesn't do that, right? I mean, that's a big mess. Not only is that a lost customer, lost revenue, but now that's even worse. People now are thinking bad things about you that aren't true.
Actually, we had a situation like that happen. My daughter got a car cover that was horrible, and she posted a bad review on their Facebook page, and it turned out to not be the same company.
Right.
And they were really, really upset, removed that. And she's like, why do you have the same name as someone else? But very interesting. So on the copyright, you bring up a really interesting point. So let's say that I have a book and I'm going into an updated version, or I have a program that I'm updating. Is this like a living document, or a website? I think is another great example that you talked about. Like, do I have to file a copyright every single time I update?
So our protection laws are designed to protect specific things in specific ways. And so they're kind of set in stone. So they don't automatically update. It's sort of like if you buy property, right? If you end up annexing part of your neighbor's land, you would have to go then redo stuff on the title in order to make it clear, well, now I actually own this strip too, right?
Mm-hmm.
Same sort of thing. So when you make significant updates or upgrades or changes to your to what's yours, then you need to make sure that your intellectual property adjusts along with it. And a lot of time that means filing a new copyright application or filing a new trademark application. Companies evolve and grow. They're really organic, and the protection laws are pretty, they're designed to be walls, right? They're designed to be rigid and strong and protect. And
Mm-hmm.
those sorts of things don't tend to naturally change.
Oh, interesting. So I get a lot of questions about licensing programs. People want to license their program IP. What's the difference between that and a copyright?
Okay. So licensing, the easiest way to think of it is like renting. And in fact, renting is just a form of licensing. So licensing is when you give someone rights to something that you own or that you're licensing, right? Generally in exchange for something. And so in order to do that, you actually have to own it first, right? So I can't walk into a library and, with you and then say, oh, I'm going to license you this chair, right? I don't own the chair. I don't have any rights to it, right? I have an implied license to sit in it, but so do you, right? So there's no, but neither of us could just walk out of the place with the chair, okay? Even if I told you I licensed it to you and gave you the license to walk out with the chair, that just wouldn't work. So first of all, you need to own what you're going to license, and that's filing the copyrights, filing the trademarks, right? Same thing if you're an inventor, filing patents. You've got to own it first. Once you own it, then you can license it. And licensing is, again, like renting. So you have a licensing agreement, which is a lot like a rental agreement. So like when you rent a car, that's a license. When you rent an apartment, that's a license. Renting furniture, that's a license. But you can rent things that you can't touch. So you could rent the right to use someone's trademark. And in the world of certified professionals, that happens with trademarks. So probably the most common certification mark that people recognize would be the movie ratings. So G, PG, PG-13, R. Those are actually owned by a company that owns those marks. They don't actually use them because they're certification marks. What they do is they license the right to use them to other people. But under certain conditions. So if I'm that company, you have to send me your movie. You have to pay me to watch it. I then tell you, based on what I saw in the movie, which rating I'm willing to license for you to, and how much you have to pay me for that license. And only if we go through that process can you actually put the rating up on the screen saying this is rated R or this is PG-13, right? So that's the same sort of, I think CPA is another one where that's a certification mark, right? And so you have a lot of certified professionals. Some of those certifications that you put after your name, they're actually trademark registrations, and you have to go to the people that own them. You have to satisfy their requirements, meet their standards. A lot of times it's like annual continuing education, you have to pass a test, you have to pay an annual fee, and as long as you do all those things, you get to use the mark. But what that does is that allows the consuming public to trust what you're providing because they see that certification mark. In the movies, they see it, they know it's not going to have more than a certain amount of whatever, right? And whereas the certification mark, they know you've at least passed a certain amount of training. Okay. So if you want to be the company that does that trains people and sends them out to the world to do their thing, and use your certification mark, then you first need to own that certification mark. And you need to have a program in place that there are standards that they have to pass in order to use it, and then you license it to them with a license
Wow, I never knew that about the rating system for the
agreement. Right.
movies.
Yeah.
Seriously, somebody owns that?
Yeah. And if you look at electronic devices, there's a mark, a UL, which is Underwriter Laboratories, and it's they own that. And what that means is if you're a producer of electronics, you sent it to them. They've checked it to make sure it's not emitting the wrong kinds of radio frequency waves, that it doesn't get too hot, that it meets all sorts of electronics requirements, right, for safety. And if you try to produce an electronics product and don't go through them and try to sell in Walmart or Target or any of the stores, right? And they look and they don't see the UL on there, they're just, no, we're not going to buy any of these, because what if it blows up in someone's house, right? You haven't proven to us that it's been checked for safety. So,
Wow, I never knew that. Wow, licensing is really complicated. And somebody's making a bundle off of PG-13.
right, they are. And their job is to watch movies. That's pretty awesome, right?
Wow, how do I get that? Maybe I can just change the standard system and have them convert to my system.
Right.
I don't know. Wait, is that X too? You have to watch all the X movies?
I don't know if they own X. I think that X is maybe something that people just made up because I think it's the MPAA is the organization that does it, and I think they just weren't willing to give anything out. Oh yeah, no, that's so actually what happened. They weren't willing to give anything out worse than honor. They didn't want to be associated with that, right? So then people started saying, well, it's an X-rated movie, right? But I don't think anybody owned that. I think people were just putting that on whenever whenever they thought it applied, right? But now MPAA has the NC-17, so they own that one, right? So there must be people paid to watch movies that are supposed to get an NC-17 rating, and then they decide whether it's appropriate or not.
So if you learn nothing else here today, you just learned how movies are rated and that somebody out there has a really cool job.
Mm-hmm.
Many people. So when do I use, now that you've given me all of these different things to think about, when do I use the copyright, the trademark, and the @ symbols? Is it @
The circle R.
Yeah, circle R.
Right. Yeah. So the copyright symbol you can put on anything that you believe that you own that's copyrightable. So if you take photographs, do illustrations, write books, do webinars, videos, anything that's recorded, in a tangible form. If you write music, if you perform music, you can put a circle C on there, the date it was published, and then your name, or the name of your company if your company is the one that owns it. You don't have to have a copyright registration to use that one. It's free to do. You don't have to talk to a lawyer. You just put it on there. And I would have a habit of using that all the time. I can't believe I'm surprised how many people have told me when they got caught taking someone else's content. Well, I thought it was free because it didn't have the copyright symbol next to it, right?
Really?
Yeah, which is not accurate. Just because it doesn't have the copyright symbol doesn't mean it's free. But that tells you that there are a lot of people out there who won't take something if it has the copyright symbol and will take something if it doesn't. So if yours has the copyright symbol, they won't take yours. So I put the copyright symbol.
So can I stop you there and ask a question?
Mm-hmm.
What if someone says freely, like, use anything of mine you want? Should you not just take them at face value and go back and get that in writing?
Well, kind of. If you're just using it for personal uses or educational uses, and not commercial education, but educational uses, right?
Mm-hmm.
You're probably fine. And especially if they come back and say stop it, you could just stop. But if it's something that's important to your business, I would get something in writing, because oral licenses to use copyrighted material can be revoked. So they could say yes today and they could say no tomorrow. And
Mm,
so if you can't handle them saying no tomorrow, then yeah, get something right. So, and that's
interesting.
another thing too, is that copyright rights can't be effectively transferred by anything except for a signed written agreement that clearly transfers those rights. So, and that includes, even if you have a signed written agreement that pays them to produce the material, they still own it, because if that agreement doesn't also clearly transfer the rights, if it just says I'm paying you to make this and you're making it for my company, it's not enough.
Okay. Trademark and the reserves, the R symbol.
Yeah, so the TM symbol you can use at any time. You don't have to talk to a lawyer. You don't have to have anything filed. Put that next to anything that you consider to be your brand. So that's, again, your company name, product names, taglines, anything that you feel is part of your brand. And then the circle R symbol, you can only use that if you have a trademark registration. So I would hold off on using that until your attorney says that you're good to go.
Okay. And it can you use that while it's pending,
Nope.
or you have to use the other while it's pending?
You can, yeah, use the other while it's pending. You can only use the circle R when it's actually registered. So if it's
And
got a
finalized.
registration number, a registration date, all those things have to be in place.
Wow, this is a lot to remember. So, Jason, where can we find you if we need to clarify some more?
Yeah. So my law firm is pearsonbutler.com, and that's Pearson, Pear like the fruit, Son like the child, and then Butler like you'd expect with one T. I have a personally branded website that's jpwebb.us, and web is with two B's. Um, so you can find me either of those places. You can also just search for Jason Webb, patent attorney. You probably find me that way too.
Okay, very good. And do you have something free you were going to give away to us today?
Yeah. So I've put together something called that I call Legal Lifesavers. It's a email program. It took me, I don't know, 6 months to put together, but it's a whole bunch of things that are free for entrepreneurs. If you sign up for it, you get something free in an email, and then a month later another thing, and then another thing, and for 20 months you get one thing a month for free, and then it just quits. They're all things that I've just designed for that I think are helpful for entrepreneurs. So some of them are like sample contracts. Like the first one's three different NDAs and instructions on how to use them, and instructions on how to pick between them.
Oh, wow.
But there's also like a guide to reduce your risk of litigation. There's also like a sort of a plain English dictionary for intellectual property and entrepreneurial terms that are legal terms. Anyways, lots of things. But yeah, so if you want to sign up for that, there's a banner at the bottom of my jpwebb.us page that you can click on and sign up. Or I think Juliet, you might be posting something. I don't know.
Yeah, I have a link we can put in as well
Awesome.
for you so people can find it. Well,
Great.
thank you so much. That was very illuminating. I learned more than I ever needed to know about the rating system, and I'm going to have to go inquire about who actually invented X.
Right. Exactly. Exactly. Yeah.
Thank you very much.
Cool. Yeah. Thanks a lot for having me, Juliet. Love it.